He had done nothing wrong. No speeding, no broken taillight, no expired tags. He pulled over the moment he saw the lights. He was polite. He was cooperative. He answered every question the officer asked. And the single sentence that came out of his mouth at minute 4 of that traffic stop gave the officer legal authority to detain him for the next 90 minutes, search every inch of his vehicle, and charge him with a crime he didn't commit. Not because he broke the law, because nobody ever told him that one question isn't actually a question at all. It's a trap with a Supreme Court case behind it. What I'm about to tell you has been confirmed by defense attorneys in all 50 states, validated by Supreme Court precedent, and ignored by almost every driver who's ever been pulled over. There is one question officers are trained to ask that sounds completely harmless, that every instinct you have tells you to answer honestly, and that has been used in thousands of cases to turn a routine traffic stop into a full-blown criminal investigation. And if you hear it, the correct response is not to answer it. The correct response is to end the conversation immediately, follow a very specific legal protocol, and in certain situations, to leave. Before we get into what that question is and why it's so dangerous, one thing. This channel covers Supreme Court rulings, changes to search and seizure law, and updates to your constitutional rights the moment they happen. Not 3 weeks later when you hear about it from your cousin, not after you've already been arrested. If that's the kind of information you want protecting you, subscribe right now and hit the notification bell. 2 seconds. Costs you nothing. And the next ruling that could save you from a felony charge will be waiting for you the moment it drops. Now let's talk about the question, the case law behind it, and exactly what to do the second you hear it come out of an officer's mouth. Here it is. Word for word, exactly as officers are trained to ask it. Do you know why I pulled you over? It sounds harmless. It sounds like small talk. It sounds like the officer is just trying to have a conversation. It is none of those things. That question is a tactical tool with one purpose, to get you to confess to a crime before the officer has to tell you what he saw. Let me show you how it works. You're driving. You see the lights. You pull over. The officer walks up to your window, and before he tells you anything, before he mentions a speed, a lane violation, a stop sign, anything, he asks, "Do you know why I pulled you over?" Now watch what happens in your brain. You start scanning backward. Did I roll through that stop sign? Was I going a little fast? Did I forget to signal? You're not sure, so you guess. And because you want to seem cooperative, because every instinct you have says that honesty will make this go away faster, you say, "Was I speeding?" Congratulations. You just confessed. The officer hadn't told you that you were speeding. He hadn't told you anything. But now he doesn't have to. You just gave him the reasonable suspicion he needs to write the ticket, to extend the stop, to start asking more questions. Even if you weren't speeding. Even if he pulled you over for something else entirely. You just handed him a legal justification on a silver platter. And it gets worse. Because in multiple circuit court cases, that exact exchange, "Do you know why I pulled you over?" followed by any answer that implies guilt, has been used as the foundation for probable cause in drug cases, DUI cases, weapons cases, and searches that turned up evidence the officer had no reason to look for in the first place. Here's a real example. Texas, 2019. The driver gets pulled over. The officer asks the question. The driver says, "I might have been going a little fast." The officer uses that statement to justify extending the stop. Calls in a K9 unit. Dog alerts on the vehicle. They find nothing. But the stop that should have taken 5 minutes took 90, and it all started with 5 words. "I might have been going a little fast." That's not cooperation. That's a confession. And the law treats it as one. Now here's the part that should genuinely disturb you. In most states, under most circumstances, the officer is not required to tell you why he pulled you over before he asks you that question. He can ask for it first. And anything you say in response can and will be used to justify everything that happens next. You are being interrogated before you even know you're a suspect. The reason this works, the reason officers are taught to ask it this way, comes from a 1968 Supreme Court case called Terry v. Ohio. That case established that during a lawful stop, an officer can ask you questions without reading you your Miranda rights, as long as you are not in custody. A traffic stop, according to the court, is not custody. You're not under arrest. You're just detained. So anything you say during that stop is voluntary, and it can be used against you. But here's the trap within the trap. The moment you answer that question with anything that sounds like an admission, you've just given the officer reasonable suspicion to investigate further. And once he has reasonable suspicion, the stop is no longer just about the traffic violation. Now it's about whatever crime he thinks you just admitted to. One question, one answer, and your entire legal position changes. That's not an accident. That's the design. Here's your response. Memorize it. Practice it. Use it every single time. I'd prefer not to answer any questions. Am I free to go? That's it. You don't say it with an attitude. You don't say it like you're trying to win an argument. You say it calmly, clearly, and then you stop talking. Let me break down what that sentence does. First, it invokes your Fifth Amendment right to remain silent. You are not required to answer investigative questions during a traffic stop. You are required to provide your license, registration, and proof of insurance. You're not required to speculate about why the officer pulled you over. Second, it forces the officer to either articulate a reason for the stop or let you go. If he has a legitimate reason, he has to tell you. If he doesn't, the stop is over. Third, it preserves your legal position. If the stop goes sideways, if he searches your car, if he arrests you, if he finds something and charges you, your attorney now has a clean record showing you did not consent, you did not confess, and you invoked your rights immediately. That sentence is a legal firewall, and it works. Now here's the piece most people miss, and it's the part that gives this video its title. If the officer continues to detain you after you've invoked your rights, after you've asked if you're free to go, and after he has not articulated a clear legal reason for the stop, you are no longer in a traffic stop. You are in unlawful detention. And here's where the law gets very, very specific. Under the Fourth Amendment, an officer cannot detain you without reasonable suspicion of a crime. If he pulled you over for a traffic violation, he must tell you what that violation was. If he cannot or will not, and he continues to hold you there, the detention is unconstitutional. Now, I need to be extremely clear about what I'm about to say, because this is the part that gets misunderstood and misused. You do not have the legal right to flee from a traffic stop just because you don't like the questions. You do not have the right to drive away just because the officer is being rude. You do not have the right to leave just because you think the stop is unfair. But if you have clearly and calmly invoked your Fifth Amendment right to silence, if you have asked whether you are free to go, and if the officer refuses to answer that question, refuses to articulate why you were stopped, and begins asking unrelated investigative questions or demanding to search your vehicle, you are in a situation where continuing to comply may waive rights you cannot get back. In that scenario, and only in that scenario, some civil rights attorneys advise the following. State clearly, loudly enough, for any body camera or dash cam to record, "Officer, I do not consent to this detention. I'm invoking my right to leave. I will comply with any lawful order, but I do not believe I'm being lawfully detained." Then wait. Do not move your hands. Do not start your car. Do not roll up your window. If the officer orders you to stay, you stay. If he orders you out of the car, you get out. You do not physically resist. But if he does not give you a direct order, if he just keeps asking questions, keeps pressuring you, keeps circling your car, and you have clearly stated you are invoking your right to leave, you are creating a legal record that may be the only thing standing between you and a conviction later. Because here's what happens next. If that stop results in a search, and that search results in a charge, your attorney is going to file a motion to suppress, and the entire case will hinge on whether the detention was lawful. If you stayed silent, if you invoked your rights, if you clearly stated you did not consent, and if the officer proceeded anyway without reasonable suspicion, everything that happened after that point may be inadmissible in court. That's not a loophole. That's the Fourth Amendment doing exactly what it was designed to do. Now here's where most people watching this video make the mistake that turns a constitutional protection into a felony charge. You are thinking this is a magic phrase, that you can say these words and the cop has to let you go and the whole thing ends there. It does not end there. There are three situations where everything I just told you will fail you, and if you don't know them coldly, you will turn a traffic stop into an arrest. If the officer tells you clearly why he pulled you over, speeding, broken taillight, failure to signal, you no longer have grounds to claim the stop is unlawful. You were stopped for a valid reason. Invoking your rights is still smart. Refusing to answer questions is still legal, but you cannot leave. You are lawfully detained until the stop is complete. This protection only works if the officer refuses or fails to give you a reason. If he gives you one, the stop is legal. Period. In 24 states, you're required by law to provide your name and identification when asked during a lawful stop. If you refuse, that refusal itself becomes a crime. This does not mean you have to answer investigative questions. It means you have to identify yourself, know your state's law before you invoke anything. If you're slurring your words, if there's an open container visible, if there's a smell of marijuana, if your passenger is acting erratically, the officer now has reasonable suspicion of a crime beyond the traffic stop. At that point, invoking your rights is still your smartest move. But you are not free to go. You're being investigated, and anything you do to resist or leave will be treated as obstruction or evasion. Here's your step-by-step response from the moment you see those lights. Step 1. Pull over immediately. Signal. Slow down. Right shoulder. No delay. Step 2. Engine off. Window down. Hands on the wheel. Interior light on if it's dark. Step 3. Wait for the officer to speak first. Do not volunteer anything. Step 4. If the officer asks, "Do you know why I pulled you over?" your response is, "I'd prefer not to answer any questions. Am I free to go?" Step 5. If the officer tells you why he stopped you, comply. Provide your documents. Accept the ticket if he writes one. The stop ends there. Step 6. If the officer does not answer your question and continues asking unrelated questions, repeat calmly, "I'm invoking my Fifth Amendment right to remain silent. Am I being detained, or am I free to go?" Step 7. If he detains you without providing a reason, state clearly, "I do not consent to this detention. I will comply with any lawful order, but I am invoking my right to leave." Step 8. If he orders you to stay, you stay. If he orders you out, you get out. You do not resist physically under any circumstances. Step 9. Document everything the moment the stop ends. Time, location, badge number, exact words exchanged, whether you consented or invoked rights, what happened next. Step 10. Contact an attorney before you speak to anyone else, including family, if anything was found or if you were arrested. The reason most drivers will never use this protocol, even after watching this video, is simple. It feels wrong. Every instinct you have says, be polite, be cooperative, answer the nice officer's questions, prove you have nothing to hide, and you'll be on your way in 5 minutes. And most of the time, that's exactly what happens. But the law is not written for most of the time. The law is written for the worst time. And when that worst time comes, the only thing standing between you and a criminal record is whether you said the right words at the right moment. You're not being rude when you invoke your rights. You're being smart. You're not being suspicious when you refuse to answer questions. You are being constitutional. And you are not a criminal for knowing the law better than the officer who's trying to get you to waive it. Before you go, I need you to do something. Think of one person you know who would answer that question without hesitation. Someone who would say, "Was I speeding?" Just to be helpful. Someone who thinks cooperation means confession. Send them this video right now, because the next time they get pulled over, the 7 minutes they spent watching this could be the difference between a warning and a warrant. This is not about hating cops. This is about knowing the game before the game starts. Subscribe if you want to know the next rule change before you need it, and I'll see you in the next one.